Please share. What's up, item 24? We have already circulated adjournment petition yesterday.
24, yeah, adjourn.
What's up, this letter may kindly adjourn.
Adjourn.
Deeply obliged.
May I please your lordships? Lordships, I beg to mention item number 16, lordship.
16.
Yes, lordship.
Yeah.
Lordship, this matter may be adjourned for 2 weeks, lordship.
Let the number come.
May it please your lordship. Lordship, I beg to mention item 23, lordship.
Item number?
23 stacked with item 22.
Yeah.
Let this matter be listed again in the next week or.
Still, this,
please, wonderful.
whatever the issue you have raised, still it is subsisting since this online stamp, this process of onlining stamps is going on last so many years.
But the
What
question
remains?
is, lordship, the used stock is still available.
Used
That we want at least
We can't.
that.
The request of the council appearing for the, you are for the petitioner.
Yes, lordship, in item number
Yeah,
20.
74 of 2023. These matters after 8 weeks. Yes.
May I give you- With the consent of other side, I beg to mention item number 18,
1-8.
18.
Yeah.
Lordship, adjournment for the 3 weeks.
But what has happened is, my lord, I appear for the appellate.
Claiming allowances. Yeah.
But what has
You have
happened
what?
is, I appear for the appellate. My lord, what happened is,
I'm
I
going to
called him up in the morning. I called him up in the morning. Their names are not reflected in the causes. He was not aware that the item is listed.
So whose names are not reflected?
My name is not appeared in the reflected in the cause list. Respondent.
After 2 weeks while reflecting the name of the council appearing for the respondents.
Okay.
May it please your lordship. My lord, I beg to mention item number 25, 26. I file an adjournment request, my lord, on.
Adjourn.
Deeply obliged.
May please, Lordship, I beg to mention item number 27 of today's daily list, Lordship. This matter may not be taken up by Lordship Council, my lord. We are challenging the order of the single bench, my lord.
The single bench order is of Leonard Single.
My lord.
My lords.
My-
Adjourn.
Item 27.
Another matter.
May it please the lordship. My lord, I beg to mention item number 31, my lord. My lord, can I pray this be taken up on the 18th, my lord, next week?
Also auspiciously, there is auspiciously on that.
My lord, this is because the conducting council is out of station, my lord, and I'm having some difficulties. 18? I'm obliged, my lord. Yeah, please, lordship.
As regards item number 34, 35, and 36. In item number 34 and 35,
Adjourn.
paying for attendance, my lord. Matter may be taken up after a week.
The urgency will go in May. Yes.
Any other request?
May please, lordship. Lordship, in item number 38, lordship, the respondent, lordship, they took my counsel yesterday, lordship.
Adjourn.
Lordship,
Wait, please, Your Honor. I pray for listing of a writ petition tomorrow, my lord. The matter pertains to eviction, my lord. It was supposed to be held on 8, but it was somehow resisted, my lord. Writ petition against an order passed by the learned CAT.
What's the order?
In the order, my lord, my application was rejected, my lord, on the first day.
Your application seeking what?
Seeking, my lord, that challenging the order of eviction, my lord, which is without show cause and
Tomorrow.
I'm deeply obliged. my lord.
Daily list for orders item 1.
Look, I have cross-checked with our details vis-a-vis the details submitted by the state. So far as Nagaland is concerned, I could find that 3, 4 infirmities, my lord,
3, 4?
infirmities.
Yeah.
Like, my lord, contradictions, like there is no medical facility in district jail Kipire as of now, although there was specific direction by this honorable court. Then, my lord, there was a direction of providing Western toilet in the jail. That is not there. Then no computer education or distant learning education is there in the jails in Nagaland. And there was another direction to provide for bunk bed, so that to take care in the winter and all, my lord. So these 4 was not there with respect to Nagaland, my lord, after cross-checking. Then, my lord, so far as Arunachal is concerned, my lord, the contradictions or, my lord, lacunas are almost identical in all the states. I'll just refer. So far as Arunachal is concerned, my lord, there is no bunk bed. No, most of the jail, there is no Western toilet. Then vocational training and computer education is not there in most of the jails. And district jail Itanagar is overcrowded. This entire proceeding initiated from this aspect of overcrowding in jail.
Yeah.
Now, for overcrowding, my lord, this honorable court set up a mechanism at that point of time that the accused who were involved in petty offences, they can be released on bail, and thereafter, my lord, suppose in a situation that bail bond amount has been fixed by at a higher rate, that can be approached, court can be approached
The
by
legal services authority can.
legal services. Those mechanisms were set into motion at that point of time. That doesn't mean that you stop somewhere. This is a continuous process, my lord. You have to do that in every spare or every 2 months or every 3 months, my lord. So perhaps that has not been done. And so far as Mizoram is concerned, my lord, 5 jails are overcrowded issue, and there is no computer education and distance learning education in central, except in central jail. Other central jail has, but other jails it's not there. And so far as Assam is concerned, my lord, we could found that, my lord, we mentioned in our reply regarding the capacity of the jail, man in place, but that details is not there in the Assam affidavit, my lord. So that is a vital document so that we can know that whether the jail is overcrowded or not, my lord. That is not there. Then, my lord, most of the jail kitchen is not up to the satisfaction. In our report, we have specifically mentioned with regard to health hygiene of the kitchen, my lord. So there is no mention with regard to the kitchen aspect. Then regarding sanitation also, there is no mention in the affidavit.
So in Assam,
Assam affidavit is, my lord, incomplete.
complete in respect of this hygiene,
Yes,
kitchen,
capacity.
hygiene, kitchen and capacity.
Yes, my lord. And so far as there is no information in the Assam affidavit regarding, my lord, Western toilet also, as well as yes, my lord, Western toilet. Bunk bed, my lord, there is nothing in the affidavit. So these are, my lord, briefly issues we have to attend, perhaps.
Mr. Das.
Yes, ma'am.
Please take a trouble
Yes, my lord.
and in brief, you please give us this in respect of this Nagaland, Arunachal and Mizoram,
Yes, my lord.
which the details they have not provided.
Yes, my lord. Yes.
So then we can ask them.
Yes, my lord. I can file a short note, my lord.
In respect of Assam also,
Yes,
you bifurcate about these 4 states
Yes.
separately.
yes.
Please bring it on. record.
Surely, my lord. Surely.
So we'll ask them to address these issues.
Address the issue.
Submit them.
Fine, my lord. Fine. I can do that.
Pursuant to the directions issued by this court from time to time, affidavits from state of Assam, Nagaland, Arunachal and Mizoram have been filed. Mr. Das, learned amicus curiae, has submitted before this court that the responses filed on behalf of the states are not furnishing complete information. It takes some time to point out the deficiencies in the affidavits in respect of the details which the states are required to explain in their responses. Stop. Time period for this granted. List up to 2 weeks.
A week will do, Milo.
This time period for this granted, Mr. Das may submit a brief analysis regarding the deficiencies in the responses filed on behalf of the states within a period of 1 week.
Well.
While supplying a copy in advance to the
Yes.
net concept of the states,
Yes.
of the 4 states, 4 respective states. The states may file their response to the same within next 2 weeks. List up to 3 weeks later, list on so and so.
7th April.
7th April. Fine.
Yes.
Highly obliged.
Item 2.
Your Lordship, here we have filed an affidavit, Your Lordship, bringing to the record the findings of the survey, Your Lordship, the list of.
Yes,
persons
you have submitted, but in your affidavit, you have also pointed out that whatever the beneficial schemes,
Lordship,
those schemes are to be implemented by the Panchayat Raj Department.
Panchayat Raj, through Panchayat Raj system, Your Lordship.
Uh,
In this
the-
order, Lordship,
As a
19
matter
for
of fact, the
24.
Panchayat Raj Department is not party respondent in this petition.
Lordship,
You are appearing for
Lordship, I am appearing on behalf of TJ Mohanto, who is the standing counsel of Guwahati High Court.
for whom? Acha, you are for the
Guwahati
amicus
High
curiae.
Court, Lordship.
Who is appearing for the state? Chief Secretary is already party. You are appearing. What about this? They have submitted their this affidavit on behalf of this council. And details about the survey carried out by the council regarding the villagers who are supposed to be the beneficiaries of the schemes. However, in the affidavit, they have stated that this schemes are to be implemented by the Panchayat Raj Department. You come to the para number,
para 5.
page number 53. In compliance of the so-and-so bringing on record the survey for identify economically backward conducted missing, it is stated that dependent survey conducted by so-and-so during the survey. These families under an amount of rupees earmarked for the same will be implemented through social science students, so-and-so, so-and-so. Be it stated that although the council has jurisdictional control over the areas, however, the role of the council for effective intervention is very limited. And most of the welfare schemes are implemented through Panchayat Raj institution over which the council has no control. So what is your roadmap?
They have taken a stand that the PRI this scheme has to be implemented. I need some time, what about this, what is the mechanism the Panchayati Raj PNRT has?
They're saying that ultimately the implementation part is by the not by the council.
On that, because Lordship, because on earlier occasion, my lord, on behalf of the deputy commissioner, we file an affidavit.
An affidavit is filed on behalf of the missing autonomous council on 24th of January 2025 pursuant to the direction given by this court on 1/3/2024 and on 14/8/2024. Stop. In the said affidavit, the council has stated that the survey for identifying the economically backward families is already conducted by the missing autonomous council in all 36 constituencies. And during the survey, it was found that 6253 numbers of extremely vulnerable families are there. And all of them falls under the BPL category. Stop. It is further stated that an amount of rupees 10 lakh earmarked for the same and same will be implemented through social science students / institutions / colleges by calling for expression of interest. However, though the council has the jurisdictional control over these areas, however, the role of the council for effective intervention is very limited because most of the welfare schemes are implemented through Panchayat Raj institutions over which the council has no control. The council for the state of Assam is directed to file a response to the said extent of the council that the welfare schemes are to be implemented through Panchayat Raj institutions which are not under the control of the council, but are under the control of the state government. Mr. Nath, praise for and granted. How much time?
But give us 4 weeks. Lordship may give us 4 weeks time.
4 weeks?
Lordship.
2 weeks. 4 weeks is too much. Well, simply, what's your action plan?
Lordship.
Obliged.
They told me 14 yeah. On 14/8.
It is
2 weeks.
Item 3.
Please, your lordship. The subject matter of the instant written is such lordship with applicant has been removed from service by the superintendent of police lordship. And on the ground of
That is PSO to one of the
lordship,
PSO,
yes, lordship. He was
Uh,
at yes,
one of the person who ordered on
yes, lordship. And lordship, so lordship, he preferred being aggrieved, he preferred WPC before the honorable single judge. And the sole contention of the applicant was that the punishment which has been imposed was disproportionate. That was the sole content. However, the honorable single judge has dismissed,
whether you were charge sheeted in that
not yet lordship.
no, in that incident where the murder took place by one that Kukul Gogoi,
Yes,
Kukil Gogoi. So you were also charge sheeted along with him?
no lordship.
No charge sheet was?
No charge sheet is filed. So for my instruction as of today, no charge sheet was filed.
The notice of the application has been served.
Lordship here, in preparing the instant appeal, Lordship, 66 days has been,
Madam,
delay has been
you are
occasioned.
referring ma'am for all the respondents? What do you want to say on this application for condonation of delay?
66 days or less.
Condonation of delay petition is not with 60 delay, lordship may condone lordship.
The matter comes upon for consideration of the IA number so. Find under section five, the limitation that there. To condone the delay of 66 days in filing the present, connected appeal will stop. The application is not seriously opposed by the counsel for the respondent. Full stop. Having heard the learned counsel for the parties and after going through the contents of the application, we are of the view that the delay of 66 days in filing the connected rate appeal is liable to be condoned. Hence, the application IA number so and so is allowed. The delay of 66 days in filing the connected rate appeal is condoned. Registry is directed to to register the connected rate appeal and list for admission up to 2 weeks.
And deeply obliged, Lordship.
Item 4.
This application is for condonation of delay, my lord, 52 days, my lord.
Five to six, you have not taken any steps for service of notice upon respondent number 5 to 6.
Yes, my lord, I will take.
You have not taken any steps.
Yes, my lord, I will take, my lord.
Yeah, pursuant to the direction given by this court on 25/11/2024. The counsel for the applicant has not taken any steps for service of notice upon respondent number 5 and 6. Then a counsel appearing for the applicant prays for 3 days time to take such steps. On taking such a step, the notices be issued to the respondent number 5 and 6 of the IA. About 6 weeks thereafter.
Item 5.
Lord, before my learned friend starts, they have filed an affidavit, my lord, on Friday, where they have tried to cover up what was not explained in the Millard's earlier application seeking condonation of delay. Now, basically, the contention of my learned friend before the other bench when the matter was listed as that my lord will try to project the records. Now, my lord, most of the averments are based on their personal knowledge because there is nothing on record to support what they have stated. Therefore, my lord, would like to file a short reply to this, my lord. Let the matter come up on next Monday. My lord.
Okay, an additional affidavit is filed on behalf of the applicants pursuant to the time granted by this court on 27/2/2025. Then the counsel appearing for the respondent pays a short time to file a response to the said additional affidavit. List on
17 my lord, Mondays.
I'm obliging.
Develop.
Item 6.
Well, there is a delay of 443 days. 443 is the delay, my lord, the filing application.
great delay.
Yes, my lord. I will explain, my lord, the delay, my lord, this, my lord. After, my lord, annexed G, my lord, page 20 and 23, my lord.
After page,
This is, my lord, annexer F, my lord.
F.
Annexer F, my lord, there's a letter from the department, my lord. Department, my lord, to the ministry to consider the judgment of the learned single judge, my lord. And thereafter, my annexer page 24, 25, my lord. 11% 25, that is, my lord, 3rd July 2024 also, my lord, there is a letter from the ministry to consider a case, my lord. My lord, thereafter, my lord, ministry was, my lord, the advice to file appeal, my lord, and accordingly, my lord, page 26, my lord, the speaking order was passed, my lord, by the Inspector General, my lord, and it was rejected, the claim of the petitioner, my lord. Thereafter, my lord, ministry, as per advice of the ministry, it was filed, my lord, this petition was filed, my lord, writ appeal is filed on 19/12/2024, my lord. 19 August, my lord, the ministry, as per advice of the ministry, it was, speaking order was passed, my lord, rejected the claim of the petitioner, my lord, considering the judgment of the learned single bench, my lord. Page 26, my lord, this speaking order, my lord.
So,
My lord, thereafter, my lord, the ministry advised to file appeal, my lord. Accordingly, appeal was filed, my lord, and this.
what was the direction of the learned single?
Yes, my lord. My lord, this out of turn promotion, my lord, according to claim of the similarly situated person, my lord, already.
Learned single judge order is-
Yes, my lord, page 74, my lord, next, this is the judgment of learned single judge, my lord. Here, the claim of the petitioner, my lord, this, one incident, my lord, they, reputation and language are similar situation, they were two part, my lord. And my lord, this, my lord, it was, my lord, out of turn promotion was, benefit was granted, my lord. My lord, according to the petitioner, my lord, he was similarly situated to some other person, he was already given from 2 promotion, my lord, but he was given only 1 promotion, my lord.
To the learned single judge has remanded the matter.
Yes, my lord, it was remanded, my lord.
And but on that remand, you have already rejected whatever his prayer was.
Yes, my lord.
So how appeal is maintained?
No, initially, yes, no, that is there, madam. The contempt petition also filed, madam, in this, during the pen.
How the appeal is?
Yes, yes.
May I just point out one thing, madam? Page 45 of the IA. It is their document, madam. Page 45 of the IA.
Whatever it may be.
Paragraph, no, madam, why the appeal, that is answered here, madam. That is answered simply, it's answered here. That is the answer I'm trying to.
45,
Page 45.
Yeah.
Paragraph 5.
yeah.
It is further observed that Lordship will find an italics part in the middle of the paragraph.
Yeah.
In the instant case, the authority has neither preferred an appeal or nor a review, and thus the order passed by the learned single judge has attained finality. The authority having passed a speaking order 19/804 setting at not the order dated 27/7/2023 passed by the Guwahati High Court is apparently a deliberate and willful violation of the honorable court's order. This was the opinion given
By?
now by the deputy SGML on when I filed the contempt petition. That was the opinion given, and because of this opinion now, since it becomes a contempt there, they have not complied with the order, they want an order in this appeal saying that already the writ petition order has been complied, so contempt can be closed. What was required to be considered was
Oh,
That is,
rightly, wrongly, whatever you
that is, yes, my lord.
place it before the this contempt court case, since the direction was to
Yes.
decide, we have decided rightly,
Yes.
wrongly, now you
that
can
will be
challenge.
decided there, so compliance would not be observed here.
Yes,
That is what I'm just.
Let's me close this, my
How
lord.
this appeal is made?
Let's me close this, this appeal, my lord.
Was this appeal, it's delay condonation, you withdraw it
Yes, my lord.
with liberty to agitate before the contempt court.
Subsequently, my lord, it was advised to file appeal, my lord, this by the.
It was an apparent contempt, they now file an appeal after there is an opinion that it's a contempt. That would reduce mean the entire contempt if that observation occurs.
The matter of the continuation of the A number so and so. With the prayer to convert the delay of 443 days in filing the connected with appeal. Stop. The connected with appeal is preferred by the appellants. You agree with the judgment and order dated. Seven 2023 passed by the learned single judge in writ petition number 6896 of 2009, whereby the learned single judge has directed the applicants, the learned single judge has remanded the matter to the applicants to consider the case of the writ petitioner who is non-applicant in this in this application, in this IA, comma, a fresh for promoting him from the rank of HC/GD to higher rank against the 10% unqualified quota. The learned single judge has granted 3 weeks time to complete the said exercise from the date of receipt of certified copy of the order. It appears that pursuant to the direction given by the learned single judge, the applicants has considered the case of the writ petitioner, comma, respondent herein, non-applicant herein, and has rejected his claim by the order dated 19th of August 2024. So we are of the view that when the direction given by the learned single judge has already been complied with, and the applicants on remand has again considered the case of the writ petitioner, respondent hearing, non-applicant hearing, for promotion from the rank of HC/GD to a higher rank against the 10% unqualified quota. There is no point in challenging the impugned order passed by the learned single judge by way of a writ appeal. Stop. In such circumstances, we don't find any case for condoning the delay in filing the connected writ appeal. The IA number so and so is dismissed. Resultantly, the connected writ appeal be also treated as disposed of.
But may I just pray one? Lordships have observed that the order has been complied with. That would take away the entire contempt petition. May I just pray that whether the order complies or not, that I will place before the municipal judgment.
The direction was to consider.
That is
On
that is what
remand
I'm
to
trying to say.
consider.
They
You
have not,
considered it rightly, wrongly, then
No,
you can
that-
very well.
what I was trying to impress is if Lordship goes to the order, my case for promotion from head constable to SI was never considered by them. They considered me for a promotion directly from constable to SI. Only that much of observation, I will have something to argue in the contempt petition.
What we will say,
Well,
now
that,
what we will say,
that whether the order was fully complied with is what I can argue with.
fully or
No, whether it was complied with, I will just have that
we
argument.
have to observe it since they acted upon.
But they have passed an order, but whether it was
They
in
have acted
compliance.
upon the direction given by the learned single judge, what remains then? Then they are not supposed to challenge that order, sir. They have acted upon that.
They've acted, that is one, if Lordship says complied, then if they've acted upon, that's another thing. If it's complied, I
In
mean,
place of compliance acted upon.
acted upon would do well. That would suffice. I'm deeply obliged.
Item 7.
Match please, sir. I have for condonation on delay of 65 days, my lord, preferring the appeal, my lord.
Earlier occasion also you remain absent four times during the training period now. What do you want to say, Mr. John?
Lordship, as it is from the impugned order, I do not see anything. But so far as
Let us see, we'll examine the
delay is concerned, Lordship, I will not oppose that.
matter comes upon for consideration of the application. IA number so and so, you declare to condone the delay of so. Please, learned counsel appearing for the respondent to oppose the application. Application having heard so and so, application allowed, this is directed to. so and so. 2 weeks.
Item 8.
May, please, your lordship.
Let 8 and 9 issue notice returnable charge.
Item 10 for admission.
Since November 2016, my lord. Since November 2016, government has 16. Government has recognized this Parangat as weird. But this was not placed before the learned single judge. But there is a notification to that extent, a notification to that extent. Notification to that extent. Malad 2003, Malad, that rule says, Malad, one has to be BA. This was, Malad, amended in the year 2018. Prior to that, Malad, BA, government has recognized BA, Malad, Parangat as BA by notification dated November 2016. This was not placed before the learned single judge, and on this basis, Malad, many persons were promoted, considering their Parangat, Malad,
Was not placed before.
This was not placed before
Then
this.
what is the fault?
neither the government,
Then what
we'll
is
have
the
to
fault
file,
in
I
the
think,
order of the learned single judge.
no, fault,
was
I'm
not
not saying
placed
any
that,
fault, but we'll have to file a review petition, that's what I'm saying. We'll have to file. Your lordship may allow me to withdraw with liberty to file review.
This writ of appeal is preferred on the.
Not very, neither government nor the petitioner doesn't even know about this
And
notification.
what about this item number 11?
Same, man.
Same. Learned concept of the appellant has frankly admitted that the a subsequent notification issued by the government of Assam Secondary Education Department dated 30th of November 2016, whereby the Hindi section Parangat and Hindi section Nishant degrees awarded by the Central Institution of Hindi Agra were treated as B.Ed and M.Ed examination respectively. Hindi section Nishant degrees awarded by the Central Institution of India as equivalent to B.Ed and M.Ed, B.Ed and M.Ed examinations respectively has not been placed before the learned single judge. And therefore, the learned single judge had no occasion to go through the said notification. Learned counsel has therefore said that he may be allowed to withdraw these writ appeals with liberty to the appellants to refer a review petition before the learned single judge. Dismissed with liberty as played.
11 same. 11 same, man. Same, 11 also same.
Same, both order, common order.
Item 12.
Two re-engagements, two reappointments have been given to the petitioner. And the petitioner's case, the reappointments have been given to respondent number 3. Now, he retired as a principal chief conservator of forest in February 2024. After that, from first March 2024 to end of February 25, the first term was given, and then now second term has been given. Reappointment. My
This
case
PIL
in
is
short,
maintainable in the matter, appointment matter.
I'll show 2 judgments straight away on the point. So the first case is State of West Bengal versus Anindya Sundar Das and others, 2022, volume 16, SCC 318. My lord, this arose out of a PIL. My lord, you will notice this. My lord will notice this at paragraph 6, your lordship.
Writ of quo warrant,
This
no
arose,
problem.
yes,
Writ of quo warrant, no problem.
yes,
That is in relation to the vice chancellors.
yes. And
Yeah, and here you are challenging a reappointment of a officer who was retired. It's basically, it's a service matter, so it's not a writ of quo warrant.
well, another case, the Harivansh Lal decision, also the second decision.
Yes.
Para 34, your lordship. This is also a purely service matter, my lord.
Quo warrant by which the appointment must be shown for the register in the-
Paragraph 34, if your lordship may have.
Ah.
From the discussion of an analysis, the following principles emerge, except for a writ of quo warranto, PIL is not maintainable in service matters. 34A, my lord.
Yeah,
The forest party.
Lord, I am relying on these two to respectfully submit, my lord, that a quo warranto would be maintainable through a PIL.
that is what we feel, it's purely a reappointment matter where the 1 year appointment has already been completed and second, again, it was
And
extended.
second, well, the difficulty is that full financial and administrative powers have been given. And the second reappointment says that this will be co-terminus with the term of the
It
state
very well
government.
says that in reappointment, these powers can't be given. But certainly, it's not a matter that they don't have power to reappoint and whatever it may be.
No,
Ultimately,
it's
a
squarely
case
in-
of reappointment. It's a case service matters.
So my submission is that, my lord, it's squarely in violation of the office memorandum 18 July 2018, which they rely upon.
That's
Secondly, my lord, fundamental rule 56D, as well as the administrative services,
Legality, that's right.
my lord.
Quo warranto, it is only for the purpose that the person who is holding that post is not entitled or not
It's a usurper.
eligible,
Right.
not eligible. That is the
Yes.
quo warranto.
Yes.
So here the difference, you are saying is appointment in violation of the OM and whatever other or something. That is altogether a different thing.
My lord.
A person eligible, suppose reappointment after a particular year of age can't be given.
My lord.
Reappointment can be given up to 62 years. And where the person who has already attained the age of 62 years, he was reappointed, then certainly you can say he is not even eligible to hold that post.
So that is my
It is
case even,
altogether-
that is my case even here, my lord, because
How?
NGT has taken note of his violations, my lord, in 4 proceedings.
Violation of what?
Well, violation of section 2 of the Forest Conservation Act, my lord, that has been taken note of, that disciplinary proceedings have been initiated, penalty proceedings have been initiated against him by the central government, MOFCC. I have enclosed that also, my lord. There's a clear question of eligibility also, which, my lord, I respectfully.
Eligibility is somewhat, a person who is not even eligible to hold the post, you can very well say. If a person suppose, any other institution is less than minimum age prescribed for that and he is appointed, then you can say until and unless he, attains that age, he can't be appointed. The co-warranto scope is altogether different. Here
That's
the-
why if I can take my law to the office memorandum of 18 July 2018, that says renewal can be given only, my lord, on outstanding performance, and renewals can be given only on satisfactory performance. Those words, my lord.
Legal appointment without ignoring that provisions, but so far as regarding eligibility is concerned, now you are very much questioning that he is not outstanding person and so and so. That requires some adjudication and not a clear-cut case where a person is not at all eligible on account of qualification, age, something. That is the main.
Not for that.
It can only be I mean to say that we can consider.
I bow down, my lord.
Only on these limited questions.
I bow down, my lord.
Eligibility vis-a-vis administrative rules, poem and something else, that is different.
I will make good my case, my lord, because the office memorandum, when it's read, my lord, with fundamental rule 56D, it's clear that, my lord, this particular officer cannot be given this extension, my lord. It was given, and therefore, my lord. And another very important aspect, my lord. The state.
রোহিত চৌধুরী আমাকে পিএল করা নাকি ফুল পিএল করে
Another my lord, commission is that the state empowered committee has been completely bypassed, my lord. The office memorandum of 18 July, the procedure is laid down.
Illegality, sir.
Illegality, my lord, and it's violation of the office memorandum, which has some sanctity, my lord.
That's violation of them, that matters at PIL, certainly. Illegality is altogether different thing from the eligibility.
My lord.
The eligibility of a person that he can't even hold this post.
My lord.
Illegality, yes, in account of these, he is not, he can't be appointed, that's another thing. And,
Because my whole case is that he is not in service anymore, my lord. Because my case, my lord, is that beyond 60 years, this person cannot be given any re-employment, my lord.
That is.
Sir, may I take your lordship to the office memorandum at least, my lord? My lord, may I have page 37, 18 July 2018, my lord. Before that, my lord, page 35 and 36 are the initial reappointments, my lord. 29th February 2024. Page 35. Subject to the approval of Honorable Cabinet, the Governor of Assam is pleased to re-engage M.K. Yadava, IFS Principal Chief Conservator of Forest and Head of Forest as Special Chief Secretary Forest for a period of 1 year with effect from 1st March 2024 after his superannuation on so and so. The remuneration of the incumbent, I'll skip this part, my lord. We'll come to the next page at 36. This is 11th March, my lord, 2024. In continuation to this department's notification number so and so, and as per approval of the Honorable Cabinet in its meeting held on so and so, the Governor of Assam is pleased to re-engage M.K. Yadava, AFS Retired Principal Conservator of Forest and Head of Forest as Special Chief Secretary Forest for a period of 1 year with effect from 1st March 24 after his superannuation on 29th February 2024 with full financial and administrative powers, my lord. So even the Principal Chief Conservator of Forest, my lord, is reporting to him today. He can initiate disciplinary proceedings against anyone, my lord. Now, my lord, this, in my respectful submission, is a clear violation of the fundamental rule 56D. Well, now the office memorandum which I was referring to, page 37, well, which in my respectful submission has great sanctity, being an executive order, no doubt, my lord. 18th July 2018 at page 37, my lord. Engagement of retired government officer on contractual assignment. Full administrative and financial power. So this is not at all, my lord, a contractual assignment. The state government has reviewed the existing strength of the employees against the current increased volume of so-and-so for efficient and timely disposal of works by various departments in the last 3 decades due to certain constraints and other procedure related issues. The recruitment for various levels of posts in the state government has not been regular, systematic, and as per the requirement of the public service delivery. At the same time, of late, it has been noticed that the attrition rate of employees of the state government due to superannuation has hastened due to the increase in the average age of existing employees. A serious shortage has been felt, mostly at grade 1 and grade 2 level, which has created a serious challenge in implementing various development schemes. Although the state government has started the process of regular recruitment and existing of vacancies, this would take considerable time, and new recruits also require sufficient time to gather expertise and skill in their respective fields. In the above circumstances, while it is expedient that whenever need arises, the state government shall make all possible efforts to increase the overall capacity of its administration through new recruitment, timely promotions, and increasing the capacity of building. It is also felt by necessary to utilize the services of outstanding and willing officers for a reasonable period of time beyond the superannuation. However, the engagement of retired officers should be made only in rare and exceptional circumstances. I'll skip the next paragraph, Miller. Therefore, superseding earlier government OM dated so and so, the following guidelines are issued for engagement of suitable retired government officials on contractual basis. Period of contractual engagement. The period of engagement will not be more than 1 year. Engagement can be terminated by the appointing authority at the notice of 1 month or honorarium in lieu thereof without assigning any reason whatsoever at any time. Remuneration, I'll skip remuneration, my lord. Procedure, next page, my lord. Page 38, this is very important. Administrative department shall assess the need for employment of retired government officers up to the age of 65 or below and prepare a proposal with the eligibility criteria like work experience required to man the position. Initial appointment shall be maximum for 1 year and the same can be renewed annually, subject to the satisfactory performance of the person so engaged. However, overall tenure of such engagement shall not exceed 5 years or 65 years of age, whichever is earlier. The proposal for re-employment will be placed by the senior most secretary for consideration and approval of the minister in charge of the department. On the basis of proposals so approved, the department will submit detailed proposals, including biodata of the
There is
officer.
a complete violation of this office member.
Yes, yes, Milord. The state empowered committee, Milord, has been completely bypassed in this, Milord. Milord.
That's all.
Therefore, Milord, therefore, a clear case of issuance of quo warranto is made out in my respectful submission, Milord.
Yes,
Because the
Mr.
state empowered committee has been given no role at all. The latest notification that has come, office memorandum, Milord, recently into February 25, they have been completely given a go by. And one more document, before my learned friend begins, if I can show, Milord. There's a MOEFCC initiation of proceedings under section 3A, 3B, Milord, which your lordship will find at page 58, Milord, 14th May 2024.
Yeah.
Page 58. This is one of 4 violations. They have initiated proceedings under 3A, page 58. My lord has it, 14th May 2024. Rule 15.3 of so-and-so, whereas clause 2 of subsection 1 of section 2 of so-and-so contemplates that notwithstanding anything contained in any other law for the time being in force in a state, no state government or other authority shall make, except with the prior approval of the central government, any order directing that any forest land or any portion thereof may be used for any non-forest purpose. Whereas the National Green Tribunal Principal Bench wide order dated so-and-so has registered suo motu original application number so-and-so on the basis of a news item published in Northeast News Now so-and-so titled Assam PCCF MK Yadava, who's respondent number 3, Millard, accused of illegally clearing protected forest of Commando Battalion. By the said order, the Honorable NGT observed that the news item raises a substantial issue regarding compliance of environmental norms. And whereas as per ministries and this office's request seeking details from the state government on the alleged violation for setting of 2nd Commando Battalion camp at Damchera within the inner line reserve forest, the same has accordingly been submitted. And on scrutiny of the said documents, it is observed that via your letter number so and so dated 28th September 23, you had been given approval for the establishment of proposed 2nd Commando Battalion within the ILRF by referring to Section 2B of Forest Conservation Act so and so, that it qualifies as an activity relating to conservation of forests. And whereas this office had conducted site visit on the alleged illegal clearing of forest land for the 2nd Commando Battalion camp at Damchera within ILRF on 8th March 2024. And accordingly, this office had observed in its report that the construction show cause notice, and they have said the last two paragraphs, if I may read, Millard. And whereas, page 59, whereas in the light of facts mentioned above, you hereby stand deemed guilty of the said offense and therefore liable to be proceeded against and punished accordingly as per provisions contained in section 3A and 3B of the said act, read with rule 15.3 of the so-and-so rules framed thereunder. Now, therefore, in exercise of the powers conferred on to the undersigned under sub-rule so-and-so, you are hereby called upon to explain your.
This is dated 14/5/2024.
24, Millard.
After the appointment of.
After the first appointment, but before the second, Millard, which has happened
Before
very
the
recently.
second, no, no, before the second, not before the second.
Well, before the second. The second appointment has happened, your lordship.
11th of
twi-
March 2024.
Millard,
11th of March 2020.
11th March 24 was the first one, Millard. The second appointment has happened, your lordship, at that your lordship will find at page 93, 21st February 25. That's the recent one, 21st February 25. So all this has not been taken into account at all. And instead, page 93, my lord. My lord, as 93. As per approval of the Honorable Cabinet in its meeting held on 16 February 25, the Governor of Assam is pleased to extend the period of re-engagement of so-and-so as Special Chief Secretary Forest with effect from 1st March 25 and co-terminus with the current term of the state government after completion of his present tenure of re-engagement on 28th February 25 till full final financial and administrative powers. And this, Millard, what they have done before this, Millard, very interesting. This was issued on 21st February 25, Millard. Just about a week, hardly a week before that, on 16th February 24, Millard, the previous page, page 91, Millard. Engagement of retired government officers on contractual appointment. A new office memorandum is, Millard, issued. It is seen that in different times, the administrative departments engaged retired government officials in the department with prior approval of the Honorable Chief Minister, and such proposals are placed before the State Empowered Committee at a later stage for its consideration approval. It is stated that the recommendation of State Empowered Committee are effected only with the approval of Honorable Chief Minister. Hence, it is felt that placing of such proposals having prior approval of the Honorable Chief Minister before the State Empowered Committee is not required in such case. The state government has since reviewed the whole matter of engagement of suitable retired government official on contractual basis, and in partial modification of this department's OM so and so, the following is inserted after sub point H under so and so. In cases where administrative department receives the approval of the Honorable Chief Minister, the administrative department may engage the retired officers so approved by the Honorable Chief Minister through an agreement. The concerned administrative department will, however, keep the SCC informed. The SCC will take note of the same and include the same in minutes of its meetings for convenience of maintenance of records. So in this, through this, Millard, they have completely bypassed the SCC. They have now completely ignored the MOEFCC's initiation of proceedings under 3A, 3B, Millard. So, Millard, there is blatant violation of rules, Millard, and this is on the face of it illegal. And 56D, Millard, which I was referring to at the outset, Millard, fundamental rule 56D, if your lordship would like to see that, Millard. I've only given the relevant rule, my lord. I have the book also. My lord, fundamental rule 56 deals with retirement, my lord. Then my lord may come to the third page of this, my lord, 56D. No government servant shall be granted extension in service beyond the age of retirement of 60 years, provided that the government servant dealing with budget work or working as a full-time member of a committee which is to be wound up within a short period of time may be granted extension of service for a period not exceeding 3 months in public interest, 3 months. Provided further that a specialist in the medical or scientific fields may be granted extension of service up to the age of 62 years if such extension is in public interest and the grounds for such extension are recorded in writing. Again, public interest and only specialist, my lord, in medical or scientific fields. The third proviso, my lord, provided that an eminent scientist of international stature may be granted extension of service up to the age of 64 years if such extension is in public interest and the grounds for such extension are recorded in writing, my lord. Provided also that notwithstanding anything contained in any rule, the central government may, if considered necessary in public interest, so to do, give extension in service to a cabinet secretary in the central government for such a period of or periods as it may deem proper, subject to the condition that his total term as such cabinet secretary does not exceed 4 years. Provided also that the central government may, if it considers necessary in public interest, so to do, give such extension to the defense secretary, foreign secretary, home secretary, director of intelligence bureau, secretary of research and analysis wing, and director of central bureau of investigation appointed under so and so, and director of enforcement in the directorate of enforcement appointed under so and so, in the central government for such periods as it may deem proper on a case-to-case basis for reasons to be recorded in writing, subject to the condition that the total term of such secretaries or directors, as the case may be, who are given such extension in services under this rule does not exceed 2 years for the period provided in the respective act or rules made thereunder, under which their appointments are made, provided also that notwithstanding anything contained in the
There are separate FR rules for the state government.
My lord, he is an IAS officer, so this will apply is my respectful submission. And my lord, because all these provisos clearly carve out.
This phase for the state of Assam,
My lord,
state of Assam FA.
my lord, because these are applicable to IAS officers across the board, my lord.
See, speaks about
Yes, yes,
the officers of the this IAS officers or not?
My lord.
What is that?
My lord, Assam rules, my lord. Because they have not referred to anything in the extensions, the 2 extensions that they have given, my lord.
Now we have.
Well, may I submit? His argument is self-defeating, my lord. On one hand, he's taking help of the OM of 2018. And he's saying that the decision is contrary to the OM. And now he's falling back to the FR and SR. My lord, will kindly pay this page 37 for a moment. That's the OM, my lord, he's relying upon. Page 37 is the OM for engagement of retired government officers.
Yes.
37.3, my lord, has seen, my lord. Sorry, clause 3, my lord, has seen page 38, my lord. 3A itself says, my lord,
Yes.
administrative departments will assess the need for employment of retired government officers up to the age of 65 years. In Assam, retirement age is 60, my lord, or below, and prepare a proposal with eligibility criteria like work experience required to man the position. Initial appointment shall be maximum for 1 year, and same can be renewed annually, subject to the satisfactory performance of persons who engage. However, overall tenure of such engagement shall not exceed 5 years or 65 years of age, whichever is earlier. So it is permissible under this notification to extend up till 60 years. Now he is saying, well, under FRSR, it is only 3 months, my lord. He was trying to take help of this notification, my lord. If my lord now perishes to page 91, my lord. Clause 3, after clause 3H of this notification, another clause has been inserted. Because here is a case, my lord, this decision was adopted by the state cabinet, my lord. Page 91, my lord, will see this by this notification, clause 3H, after clause 3H, I has been inserted. This I has to be inserted after 3H. Second paragraph, if I may read, my lord, the state government has since reviewed the whole matter of engagement of suitable retired government officer or contractual basis, and in partial modification of this department's OM dated so and so, 18/7/2018, that's the notification, my lord. The following is inserted after subpoint H. under 3 of the procedure of engagement. It says, in cases where administrative department receives the approval of the Honorable Chief Minister, the administrative department may engage the retired officers who are approved by the Honorable Chief Minister through an agreement. The concerned administrative department will, however, keep the SEC informed. The SEC will take note of the same and include the same in the matter minute of its meeting for convenience of maintenance of records. So the requirement of going through the SEC has been done away with if a person is selected by the Chief Minister, my lord. There is a case, well, the decision was adopted by the cabinet. So now he's saying, well, the entire procedure of going through SEC has been violated. That has been done away with.
No, I have challenged this also, my
No,
lord.
merely making a challenge will not suffice, my lord. There has to be grounds.
I'll make good my challenge, my lord. What are the role?
May submit on that. Yes. Well, page 93, by which my lord his re-engagement was extended, my lord, may kindly perish. I have only two small submissions to make, my lord. Page 93. Yes. As per approval of the Honorable Cabinet in its meeting held on 16/2/2005. So this is a manifestation of an order adopted by decision taken by Cabinet, my lord. That is the parent decision, my lord. That is not under challenge, my lord. That's a Cabinet decision. And secondly, my lord, this, my lord, modification of the OM, earlier OM, which the foundation of the petitioner's case, my lord, page 91. It was made way back in 16th of February 2024. This gentleman was once granted extension, my lord. Petitioner was not agreed. It was done in 2024. After more than one year, my lord, he has not only assailed this engagement, but also assailed this modification of 2016. And para 27 is the only submission where he says that, my lord, because of this modification, now the SCC is now subservient to the Honorable Chief Minister and Cabinet. That has to be, my lord. His only argument, my lord, page 20, paragraph 27, this submission in support of his challenge to the validity of this modification at page 20, paragraph 27, page 20, my lord. The petitioner begs to state that, page 20, my lord, paragraph 27. The petitioner begs to state that a few days prior to the issuance of notification dated so-and-so, the respondent authorities, right, OM dated 16/2/2024, completely negated the necessity of consideration of cases by the state empowered committee in as much as it was provided by the said notifications dated so-and-so, that cases where prior approval has been granted by the Honorable Chief Minister, the administrative department may engage the retired officer through an engagement, and the SCC will merely take note of the same in the minutes of its meeting for convenience and for maintenance. As such, no detailed scrutiny of the credentials of the retired government servant sought to be renamed is done, re-employed is done by the SCC, which is reduced to a mere post office to maintain records. Has to be, my lord. If it is a decision taken by Honorable Chief Minister, adopted in the state cabinet, my lord, SCC cannot be superior to the cabinet and to the Honorable Chief Minister, my lord. The SCC was required wherein, my lord, the departmental minister or department proposes a re-engagement. So that in respect of a person picked up by Honorable Chief Minister, approved by Honorable Chief Minister, that has been done away with, my lord. And rightly so. Only merely because the challenge has been made will not suffice, my lord, because there has to be grounds, my lord, to maintain the challenge, my lord.
Yes.
Three documents, three orders will answer my learned friend's argument, my lord. Page 56, if your lordship has. This is an order passed by the Honorable NGT, my lord, Principal Bench, New Delhi.
We are not on the.
My lord, these are prima facie, these are prima facie.
We are simply regarding maintainability of the petition preliminary. We are, we'll see if it is maintainable, then we'll proceed further. If it is not maintainable, not proceed
My
further.
lord, let them then file a response, my lord, if
No,
it
they-
requires consideration. My lord,
For the purpose of maintainability, we don't find any reason to.
my lord, may I then through these orders, I'll leave it at that, my lord. Page 56, the order of NGT, my lord, clearly records. What I would press to, my lord, submit before your lordship is that this order was passed on 23rd of April 2024, my lord.
Yeah.
They take note of the violations in Barak Valley where forest land amounting to about 44 hectares of protected forest land was diverted for a commando battalion headquarters in Barak Valley and illegal construction for that purpose inside the inner line reserve forest and so and so. But this paragraph which is extracted is from MOEFCC's order, my lord, affidavit before the NGT, paragraph 2. In terms of the direction of the tribunal, counter affidavit on behalf of MOEFCC has been filed disclosing the status as under. The regional office so and so, via its letter dated so and so, sent its detailed site inspection report vis-a-vis allegations of violation of statutory provisions of so and so rules. The said report has been examined in the ministry and prima facie it has been observed that the use of forest land for non-forestry purposes has been allowed without prior permission of the central government, which is in contravention of the statutory provisions and rules under 1 Adhiniam 1980. That taking note of the aforesaid answering ministry via its letter dated so and so, directed the state government to stop and discontinue the alleged construction activities forthwith. That by letter dated so and so, ministry also required its regional office Shillong to initiate action as prescribed under 3A and 3B, which I pointed out to your lordship. Affidavit clearly reflects the construction has been done in utter violation of the norms. Learned Advocate General appearing for the state has submitted that the construction activity has now been stopped and has sought for 4 weeks' time to so and so. He has further submitted that an application has been made to MOFCC for permission, which is pending. Lord, then another order in case of another violation, your lordship will find at page 60.
They have granted time, so this, I will consider all this. Yes,
Right.
I heard when I consider the parties on the issue of maintainability of the writ petition. Goes for orders. Order reserved. Order reserved. Order reserved.
Item 13.
Another writ appeal is already there.
All lordship, may I kindly tag with lordship writ appeal 12 of 2020.
Against the exhumed judgment.
Lordship, same judgment, lordship. This is with regard to upgradation of the assistant executive engineer. The other writ appeal was filed jointly for both the promoted and assistant executive. For both the promoted and upgraded assistant executive engineer, that writ appeal was filed.
Just along with writ appeal number 12 of 2023. Notice we have to issue the notices in this writ appeal. Issue notice to the respondents. Returnable. 4 weeks. And it council may take steps for service of notice upon the respondent within a period of 3 days or 1 week.
10 days.
10 days, explaining with the issue notice, learning concept from the appellant is granted 10 days time to take steps for service of notice upon the respondents. On taking such a step, that notice is issued to the respondent, returnable. 4 weeks thereafter, after service of notice upon the respondent, list this writ appeal along with writ appeal number 12 of 2023.
Item 14.
My lord, this is an appeal, my lord. Against the order dated 23/1/2025, passing the writ petition, my lord. Whereby the lornet, my lord, single judge held that, my lord, there is no, my lord, illegality in the passing the resolution that is on 25/7/2024, removing the, my lord, petitioner from the chairmanship of the Titavur Municipal Board and appointing on the same day the another, my lord, respondent number 8 as the chairman of the same board, my lord.
That issue regarding your removal, that has attained finality.
My lord, the issue is only one thing, my lord.
That has attained finality.
Yeah, attend the finality, my lord.
That up to division bench, you have lost your case.
No, my lord, this is a separate issue. Now the issue is a totally different because, my lord,
So now I issue that within 45 days, new elections for this chairman has not taken place
yes, my lord.
from that date. But on very same day, on 27/10/2024, they have appointed respondent number 8 as chairman.
Yes, my lord.
Ultimately, the respondent number 8 resigned,
Yes, my lord.
and thereafter new elections took place.
Yes, my lord.
New elections, now the new chairman is there. What's
No,
wrong in that?
one thing is there, my lord, the as is resignation is not in so moto, my lord. The resignation of the respondent number 8 was not on so moto, my lord.
Sir, you have-
That is, no, one thing, my lord,
No,
kindly
listen.
bear with me, my lord.
His appointment as the chairman on 27/10/2024 was not challenged by you at any.
No, no, that is challenge, my lord. This is a wrong finding of the court, my lord. I have showed you, my lord, where the paragraphs there.
What happened in that challenge?
My lord, the 25/7, that was I have challenged,
What happened then?
my lord.
In that challenge, what happened?
My lord, regarding the appointment of the respondent number 8 as the chairman.
What happened in that challenge? Writ
The
petition
challenge,
or
my lord, that
whatever
was-
the proceedings, what happened in that?
My
writ
lord,
petition?
in that proceeding, my lord, because that was whenever we have challenged the initial appointment of this chairman, then the first writ petition. And that writ petition, my lord, that was dismissed and again appeal was, my lord, lost. Then, my lord, what happened? We came to know that on 25/7/2024, while the, my lord, chairmanship was removed, on the same day, my lord, respondent number 8 was appointed.
Yeah.
But one thing, my lord, in the later subsequent, my lord, one meeting was held. By that meeting, it was held that the decision and meeting held on 25/7, that was illegal for want of 3 days notice, violation of the 46th
Therefore, he has
4.
resigned.
So everything, my lord, is gone in that day. So that means in my chairmanship still prevail on that day, my lord. If the, my lord, meeting that was conducted on 25/7/2024 was, my lord, held was a null and void, then the entire process is null and void, my lord.
No, which process?
My lord, 25/7, my lord. Kindly have a look at the annexer K of my petition appeal, my lord.
25/7/2024, whereby a no confidence motion was passed against you.
Against you and again the same day, my lord, petition respondent number 8 was
There
appointed.
are two separate things.
My lord,
One was your removal
but the same,
on account of passing of no confidence motion, and another was election of the respondent number 8 as chairman. These are the two separate incidents.
separate incident, but the incident was the same day. And one thing, my lord,
They altogether different. There are two separate incidents. One is your removal on account of acceptance of no confidence motion, and
Yes, my
another one is the election. You
My-
challenged that no confidence proceedings by way of filing a writ petition. That writ petition was dismissed. Then you approached the division bench. The division bench has also dismissed your writ appeal. That the matter and
that was end. That
matter
was
was closed regarding passing of no confidence motion against you.
But the subsequent petition came, my lord, kindly have a look at the annexer K of, my lord, this is my petition, my appeal, my lord.
Subsequent writ petition filed by you
Yes,
challenging
challenging, my lord, that 25/7/2000 resolution.
election of the respondent number.
Yes, my lord.
During the pendency of that writ petition, he resigned.
Actually, my lord, the nullity of the, after nullity of the entire proceeding, he, my lord, he resigned.
Wait, maybe he resigned.
But the,
He resigned, and
yes.
after his resignation, a new meeting was called for the purpose of electing a new chairman. 3 days notice was given to you. You chose not, you have chosen not to attend that meeting. In that meeting, the new chairman was,
No, my lord,
the same person was again elected as a chairman.
but the second notice is issued by the vice president, my lord. While, my lord, my post was still there, I was holding. If the, my lord,
How you were holding? You were
because,
removed
my
on
lord,
account of
kindly,
no confidence
no, my
motion.
lord, no,
Immediately
kindly,
the no confidence motion
kindly-
was passed, you were removed.
my lord, kindly, if the, that no confidence mission is already been nullified by the subsequent notice, meeting, my lord.
Which?
So, this is but the meeting was held on, my lord, 21/10.
It it is not open for us to look into the proceedings regarding no confidence motion that has attained finality up to division bench.
But that was done illegally. That was declared illegal and nullified then by the subsequent resolution of the meeting of the same board, my lord.
Judge has taken note of it and said that now we can't look into all this, whether this no confidence motion was passed against you legally, illegally, that has attained finality.
But thing is that but the meeting itself saying that the 133 days prior notice, that was illegal. So same thing was the I also
That
pleading.
was in relation to the appointment of the new or election of the new chairman. For that, 3 days notice was required, but on that day, they have illegally elected the respondent number 8 on the very same day, on the day you were removed.
My lord,
And that's why only he resigned and again the process was followed and he was appointed.
my lord, one thing, my lord. The first notice was issued on 18/7, my lord. For meeting a hold on 20, that was failed because of the quorum. Then 24th, again, notice was issued and 25th, my lord, meeting was held, by which I was removed and he was appointed, my lord. This is the things, my lord. How one day notice can be issued?
Mr. Mehta, please try to understand. Now it is not open for us to look into the proceedings where was the no confidence motion was passed against you. That was closed. For all purposes, that was closed. Now you are claiming since his election was illegal on that day and therefore you will be deemed to be a chairman, that is not possible.
But that is on the basis of their document, my lord. This is not my document, my lord. Whatever subsequent development has been occurred,
Huh?
whatever subsequent development occurred, that it came to light that this thing was happened on that day, my lord. That was not in my knowledge in that particular day, whenever I challenged the, my lord, my removal on 25th, my lord, because the same subsequent resolution was taken on by the same
May
committee.
not be in your the knowledge, but ultimately you are basically aggrieved by your removal on account of passing of no confidence motion.
That is true.
That was already adjudicated by the learned single judge as well as the writ court, appellate court, and you failed to get any relief. Matter ends there.
But that removal that to be approved by the government, but till today it is not been approved by the government.
That the learned single judge has taken note of it. There is no provision that approval of this government is required in a case of no confidence motion. That has been taken care of. That's all.
That's all, my lord.
Close for orders.
Must be.
Item 15.
Another appeal is pending by the ONGC. What's the number in there?
It is 66 of 25.
16?
66 of 2025.
Notice. Mr. So-and-so accept notice on behalf of the respondents, all the respondents.
All the respondents. Should be, we don't have a copy of the opinion. Should be all the.
The Oil and Natural Gas Director, Disciplinary Authority, ONGC, Group General Manager, ONGC, Executive Director, Basin Manager, ONGC, and the General Manager, ONGC.
All.
So, so-and-so accept notice on behalf of all the respondents. Is notice that against the impugned judgment an appeal is also preferred by the ONGC. And writ appeal number 66/2025 is also preferred on behalf of the ONGC, which is already admitted and listed for hearing in due course. In such circumstances, admit no need to issue notice to the respondent, there's no need to issue formal notice to the respondents. List this writ appeal along with writ appeal number 66/2025 in due course.
Deeply agreed.
There's a case, all parties are agreed. Perhaps.
I'm just agreed by part of the judgment, man. The back wages.
The counter to your appeal.
Right.
Item 16.
(29/7/2024), this court has raised some query. You have not answered that query till date.
Lordship, actually, some of the affected persons, or Lordship, they want to join as the petitioner in this PIL,
Then
Lordship.
ask them to find this, when we asked you that why those persons are not, how those persons are incapable of accessing the court themselves, you said, "Okay, I'll satisfy," and now if those persons are coming, then why we allow you to continue with this PIL? They will come and will consider that plea.
Lordship,
This
then-
can't be, this PIL matter, you are misusing it many ways. Any person is coming and filing an PIL without even complying with the rules of the PIL. We can't allow it.
Lordship, then let me withdraw this petition and file a fresh one with.
Pick here this court. By order dated 29/7/2024. Directed the petitioner to satisfy has observed on 29/7/2024. This court has observed that this PIL petition is filed on behalf of the petitioners without specifying the class of persons for whose benefit the petitioner has been filed, and as to how such persons are incapable of accessing the court themselves, as required under Rule 10(4), 10 in bracket 4 of Guwahati High Court Public Interest Litigation Rules 2011. The counsel appearing for the petitioners pays some time to satisfy the court on the aforesaid aspect. However, till date, no material is placed on behalf of this court, on behalf of the petitioners to satisfy the query raised by satisfy the query raised by the order 29/7/2024. Despite granting several opportunities, today, the counsel for the petitioner has submitted that he may be allowed to withdraw this PIL petition with liberty to approach this court again with full details. This with liberty has prayed for.
Deeply obliged, Lordship.
Item 17.
May please use the Lordship. My lord, in this case, my lord, the APDCL, the Assam Power Distribution Company, my lord, had issued a tender, my lord. The respondent.
Notice. Also.
Item 19.
Lordships, the central government for the amendment of the Wildlife Protection Act 1972.
You have raised the evidence regarding the space
Yes.
provided to this various animals who were kept, who were made captive in the zoo. And you relied upon some this specifications Standard and something which were, this, minimum dimensions of, enclosure for housing exotic animals in different species.
Yes, Lord.
And you are relying upon some, this, information which you have received under the RTI. But you have not mentioned that, what is the, deficiency, what is the requirement? Why don't you, give us a chart? That in respect of this species, so and so space is required where as per this and they provided only so and so space. Where is that chart, sir? Now you have left it for the court to look into this, what discrepancy is there. This is the job of this is your job. You should have provided the details.
Lordship,
That as per the information received from the RTI and as per those standards.
These are the
What are the deficiencies? You have to point it out. Now you can't leave it before the court. You have placed these two documents and now find out what is the discrepancy. Give us the details.
okay, I will file another affidavit then.
You please file affidavit that what space is required and they have provided only that much of space. In many cases, they may have provided more than that, the required space. So point it out. The petitioner, I think so you understand our query.
Lordship, I understand.
The petitioner present in person, place some time to place on record a detail report regarding the discrepancies in providing minimum dimensions of the enclosures for housing exotic animals of different species in the which is that you
In 3 of states, my lord, Assam, Nagaland and Arunachal Pradesh.
in Assam, in the Jews of Assam, Nagaland and Mizoram,
Arunachal Pradesh, my lord.
Arunachal. एक मिनट बताना List after
4 weeks, small. 4 weeks. Submission, my lord. Perhaps my lord, cost title also needs to be changed, my lord. Perhaps my lord, cost title also needs to be changed. State is not a party, my lord. Only PCCF is a party, my lord.
do the needful. If the
State
state
of
is
Assam,
required.
State of Arunachal Pradesh. Lordship, much obliged.
Item 20,
May it please the Lord.
Pleaded guilty.
Lordship, guilty was, my lord, I am relying, my lord, the judgment of the Honorable Supreme Court, my lord.
The Supreme Court says that
But there
even
is,
though if
my
you
lord,
plead guilty, then also,
no, there is a violation of the, my lord, procedure, my lord.
why?
Rule 49(3), my lord, was not complied with, my lord, in its spirit, my lord.
49C,
Lordship.
it's about ascertaining whether that
And
your admission or confession is free
Lordship.
from any force or what?
And here, my lord, paragraph 33, my lord, and 42.
Yeah,
33, my lord, regarding, my lord, confession was made, my lord, during a open arrest, my lord. And
but here it is not proved that you were under house arrest.
he was at house arrest, my lord. He was kept in house arrest, my lord.
Notice, this one, so accept notice on behalf of
All
the respondents. Having heard the learned concept of the parties, we are of the view that the matter requires consideration. The learned concept of the petition, appellant place reliance on the decision of the Honorable Supreme Court rendered in Union of India and others versus Yogeshwar Swan, reported in so and so. You take note of this, reported in so and so. He has submitted that the procedure provided under Rule 49(3)
Lordship
of
of BSF rule, my lord.
BSF rules have not been complied with by the authorities concerned. Having heard the learned concept of the parties and after going through, having heard the learned concept of the petitioner, we deem it, we are of the view that matter requires consideration, hence admit. Issue notice, learned concept, Mr. So and so accept notice on behalf of all the respondents. Service is therefore complete. Learned concept of the respondent may, by response to the writ appeal within a period of 4 weeks, list the matter in due course for hearing.
Oblige. Oblige.
Item 21.
Another readable is already pending, my lord.
Yeah,
Another readable is pending against the same judgment.
by whom?
By here altogether 257 petitioner in the writ petition. Out of 257, 15 earlier came. So their appeal is already there and this order is passed. First time notice issued, second time there is observation. Admit. One, notice. Notice. Muru naam.
We can learn a concept of the petitioners have submitted that. Against the impugned judgment. Another writ appeal, number, writ appeal 297/2024 of pending consideration. List this writ appeal along with writ appeal number 297/2024.
I don't know.
Item 28 and 29.
Lordship, issue involved is whether we can deduct from the gratuity by exercising power under Rule 71 of the pension rule, Lordship. There is one more case, Lordship, there is 1286 of 2025. That all the cases may be heard together. Pending, Lordship. WPC 1286 of 25. 2025.
Whether notice has been issued.
Notice has been issued, Lordship.
In that 25 matter.
Lordship.
And here the also notice has been already.
They have appeared,
Yes,
Lordship.
in item number 20.
In that 25 appeal also a stay is there.
Stay.
Okay. List along with writ petition number
1286.
1286/2025. Since it's a matter of final, we'll list all these matters for final hearing. Earlier. For final hearing in the month of 3rd week of May 2025.
Item 30.
May please the lordship. In this matter, the arguing counsel, Mr. D. Saikia, is out of station today. So can it be on?
Where is he?
Your lordship?
Where is he?
As per my instruction, Dubai, your lordship. Sineka.
Why you are here? Why you are here? After 6 weeks.
Item 32 for hearing.
Wait, please, my lord. My lord, in this matter, challenge has been made to the Payment of Bonus Amendment Act, my lord. Affidavits have been filed by the respondents saying that payments have already been made to some of the, in some of the tea gardens as per the amended act, my lord. The bonus. Yes, my lord. My lord, I pray that some time may be granted 2 or 3 weeks, my lord, so that, my lord, the association under which all the gardens are, we can obtain the instructions whether the payments have been made or not, my lord.
Payments have already been made.
My lord, I have filed 2 affidavits, my lord. In one affidavit, I have submitted in 78 garden payment has been made. Pardon, 78 garden. And another 147 garden payment has not been.
So, since the payment has been made, the challenge has become infructuous. You, verify that.
My lord.
Okay. Learned counsel appearing for the petitioner takes some time to verify the fact that after the proposed, after the amendment in the Assam, what's the name of that?
Assam Staff कर्मचारी Shankar.
Assam?
Staff कर्मचारी Shankar representing the workmen.
No, that act.
That is the payment of bonus.
Payment
Payment of bonus,
15, my lord.
bonus amendment act 2015.
At page 47, my lord.
Bonus amendment act 2015, whether the wages have been paid to the
Employees.
as per the amended act or not. This after how much time?
4 weeks, my lord. Obliged.
This after 4 weeks.
And your obliged.
Item 33.
Yeah, please, about it. My lords, on receipt of the appeal memo, the respondent number 1, who is the writ petitioner, he came to know that a writ petition was filed in his name by some imposter. By some imposter. He didn't file that writ petition. So accordingly, your lordship directed on 9/6/2023 for a police inquiry. The inquiry was conducted, my lord, and thereafter a report was submitted by the SP Dhubri.
This very much person has filed.
The same person, the signature on the wakalatnama, and this is same person. However, my client says that he doesn't know anything about the case. So I am unable to I have no instruction to argue the matter. Otherwise, on merit, it can be heard. Respondent number 1, my lord.
Respondent number 1.
Jaydev Das. It can be heard on merit.
But since
Managed him or what? So managed him or what?
no, my lord, no. Yes, my lord, come up with all the affidavits, all,
Because
my lord.
the selection process started because of
And this fact
on
would
the
also,
employment exchange.
this fact would also reveal from the, my lord, records that the RTI applications were done by one Bimal, some Mandal, my lord, Balaram Mandal. And he wanted to file the writ petition, but for some reason, he did not file. This name of the present petitioner has come up. So the documents, whatever has been annexed, that has been received by the Balaram Mandal.
But once the court has adjudicated the matter, we have to hear on merits.
And so far as the demand, the complaint or the representation he has filed, his grievance was only with regard to that. He has filed an FIR against the present appellant, number 1. And since criminal case is pending, so police verification is not correct. That was his grievance. He had nothing he has said about the selection process, etc. This representation, your lordship may kindly see at page 73. That was his original grievance, page 73.
We have on merits.
Lordship,
Some
even
other-
on merit, my lord, will,
Some
Lordship-
other day.
Lordship,
It's after 2 weeks.
no, Lordship.
Item 39.
Lordship, on fifth year, the honorable court had directed that certain other matters be listed with this matter. The other matters are not tagged, my lord.
2, 3 matters are there, exclusion of that Jola community.
Lordship. Same notification is under challenge.
What is the number?
Lord, I'll provide them.
List along with so and so, so and so.
My lord, I'm only paying for short date because, my lord, we are not enjoying the benefits. of
Along
it.
with that, we have already fixed some dates in that.
No, my lord.
That is
only-
there. We recently, last week it was listed and we have.
Yes, lordship had said that list these matters along with PL 56/23. That is the order.
With this.
Yes.
Okay.
So I'm paying for date. my lord.
April,
First week of April, man.
April second week,
After the.
after the.
My lord.
Much obliged.